For a clear statement rule or clear indication is that the underlying constitutional question is one that we haven't had to squarely answer for 236 years.
Yeah, and the exceptions clause, if you were going to address the exceptions clause and the scope of Congress's power there, it would not be in the context of a habeas appeal. Because at the founding, it's well established that there was no right to appeal at all the denial of habeas. It was not in this court's or any court's appellate jurisdiction. And so the idea that there would be an exceptions clause problem is just completely ahistorical.
So we get out of that, in your view, because this is just different because it's habeas?
It's habeas. I mean, and there's just no founding era principle that would have applied here. Moreover, there are some bases for review. I don't think that.
Yeah, what are those?
Yeah. So, first of all, I think as Justice Barrett indicated, this court could, if the court took the interpretive approach that we did here, I think its decision on jurisdiction would effectively announce the proper interpretation.
Would the lower courts have to follow that? I think not.
You know, I would think it would be a pretty willful.
Well, what would we do if they didn't?
Well, if you didn't, there is the question of sua sponte en banc, which we can discuss. But if you wanted to address it specifically, I think there's a question of a certified question to this court.
And if it's not certified?
Well, first of all, I think the Court of Appeals misunderstood the certification standard. The certification standard here is whether it's appropriate in a rare instance when advisable in the proper administration and expedition.
The only point I was making is that it seems pretty cute to kind of have a collateral dicta and expect everyone to follow that when we're openly saying, under your view, no jurisdiction.
It depends on how the court writes the opinion. I think it's not the court will not go out of its way to escape the rule on the merits when addressing jurisdiction. But if you agree with us, the natural way to do that is to analyze the statute in a way that will carve out.
Mr.